My favorite artist from the 80s, Prince, had a $150 million estate. And when he died, he had no will, no trust, and even years later, his family is still fighting over his entire estate in court. If someone with that kind of wealth and that many advisors could get it wrong, you can see how easily everyday families fall into this same trap. My name is Chris McClure, and after 31 years of guiding families through estate planning, I've seen these 5 mistakes destroy more inheritances than market crashes ever could. They're not just about taxes, they're about leaving your family exposed, confused, or sometimes even permanently divided. So let me walk you through each one with real stories that show exactly how they play out. So mistake number 1 is leaving assets outright. So this feels like the simplest approach, right? Write a will, you say, leave everything to the kids, check that box, it's done. Except when you leave assets outright, they're completely exposed. They're exposed to your children's creditors, they're exposed to lawsuits, and they're exposed to divorce. I worked with a family who left a 7-figure inheritance directly to their son. Responsible guy, solid career, he was married with kids. 5 years later, he got divorced. And because that inheritance was in his own name, the family court classified it as marital property. So half of it disappeared in the settlement. That certainly wasn't what his parents intended, especially when they spent decades building that wealth. I've seen another pattern with business owners. A client's daughter inherited assets outright and used the money to expand her consulting practice. When a former employee sued for wrongful termination, that inheritance became fair game in the lawsuit. So she settled, but unfortunately, most of that money was gone. Once money lands directly in someone's name, it's legally theirs, and so courts and creditors can reach it. The alternative is a trust structure. Think of it as a protective wrapper around your inheritance. Your children still get the benefit. They can use the money, they can invest it, they can enjoy it, but it's shielded from creditors, from lawsuits, and from divorces. One family I worked with established these structures for both their children. Years later, their daughter went through a contentious divorce. The trust held, her inheritance remained untouched, while her other assets were divided. She told me later it was the only financial stability she had during that period. And you see, that's the difference between leaving assets outright and protecting them. Mistake number 2 is skipping what I call bloodline protection. You see, even sophisticated families miss this one. Without what I call a bloodline trust, wealth has a tendency to drift out of the family. You see, you leave everything to your daughter, and then unfortunately, if she passes away and her husband inherits it, if he gets married a few years later, your life's work could end up funding his new wife's children instead of your grandchildren. One client put it perfectly. He said, I want my grandchildren to benefit from what we built, not my son-in-law's next family. You see, bloodline trusts, they ensure that your wealth flows through your descendants, through your kids, your grandkids, and possibly even your great-grandkids. Not sideways, not to a second spouse, and out of the family line. I worked with a family who established these structures for each of their 3 children. Unfortunately, their oldest son passed away unexpectedly at 45. His trust assets were there to help his wife and the kids, but ultimately they've flowed directly to his children and not to her when she later got remarried. And those grandkids used the money for college, for graduate school, and for starting their career. Compare that to another situation I encountered. They had no bloodline provisions, and when their daughter died young, everything went to her husband. And he eventually remarried, which is perfectly normal. But unfortunately, when he passed, most of that wealth transferred to his new wife's children from her previous marriage. The original family's grandchildren received nothing. So families who built substantial wealth, multiple properties, businesses, investment portfolios, they almost always implement bloodline protections once they understand this risk. Mistake number 3, and this is sort of obscure, is owning life insurance inside your estate. See, this trips up even the most experienced professionals. And you buy life insurance thinking you're creating tax-free money for your kids. But if you own the policy in your name, the IRS treats it as part of your taxable estate. And so I've seen family lose 40% of what they thought was tax-free death benefit. A $5 million policy becomes a $3 million policy after inheritance taxes and estate taxes. The solution is an irrevocable life insurance trust or an ILIT. Instead of you owning the policy, the trust owns it. And this keeps the death benefit outside your taxable estate. I worked with a physician who had accumulated a $3 million life insurance policy in his career. He intended to have it fund his grandchildren's education. When we reviewed his estate plan, we discovered that the policy was still in his name, and at his death, the estate taxes would have consumed about $1.2 million or so of the benefit. So we transferred ownership to a properly structured ILIT with annual exclusion provisions. When he passed 3 years later, the full $3 million flowed into educational trust for his grandchildren. Not a dollar went to the IRS. I've seen the opposite scenario too many times. A business owner with a substantial policy and no trust structure. When he died, nearly half of the death benefit went to estate taxes. His children were shocked to learn their inheritance came with a massive tax bill. So for families with significant estates or business owners who rely on insurance for liquidity, proper structuring makes the difference between a family asset and an expensive mistake. Mistake number 4 is having outdated documents with the wrong people. And I see this pattern constantly. Families complete their planning once, they file the documents away, and then 20 years pass. Suddenly the executor is an ex-spouse, the trustee is someone who died a decade ago, the guardians for their minor children are people they haven't spoke with in years. I actually reviewed one estate plan where the named trustee was a college roommate, and the client hadn't had contact with him in 25 years. When I asked about reaching him, the client realized he didn't even know if the man was still alive. So it's not just about outdated names. Laws evolve, tax codes change. What worked effectively 15 years ago might be completely obsolete today. A widow came to me after her husband's sudden death. Their documents were from the early 2000s. The primary trustee had died. The backup trustee lives overseas and had really no interest in serving. And the trust provisions, they referenced tax laws that no longer existed. Another family designated their oldest son as trustee in the 1990s. By the time we reviewed everything, that son had filed for bankruptcy and was facing ongoing litigation. Leaving him in charge would have exposed the entire trust to creditors. Families with complex estates need to review their plans every 3 to 5 years. Major life events require immediate updates. Births, deaths, divorces, remarriages, or even moving between states. Effective estate planning isn't just having documents, it's having documents that work for your current situation and the people actually in your life today. And mistake number 5 is avoiding difficult conversations. See, this is the hardest mistake to address because it's about human nature. People simply don't want to discuss their own mortality or their family's future without them. So they delay the planning, or they complete documents once and never revisit them. I've actually seen clients draft the documents, but they never sign them, or they just avoid the topic entirely. You see, when that happens, families face chaos. I saw one family where the father died with no estate plan whatsoever. No will, no trust, no documented wishes. His children spent nearly 2 years in probate court. They paid tens of thousands in legal fees, and the relationship between the kids were damaged by disputes over his intentions. And that's what happens when you avoid it. I've worked with other families who approach it differently. The parents initiated family meetings, and we helped them with it. They explained values, they explained their wishes, their reasoning. They prepared their children for the eventual responsibilities. When those parents passed, everything proceeded smoothly. The children knew exactly what to expect and how to handle their responsibilities. It wasn't fun conversations, but they were necessary, and it actually worked. The contrast is stark. Avoid the conversation and leave behind confusion and conflict. Have the conversation and leave behind clarity and unity. See, those are the 5 critical mistakes. Leaving assets outright without protection, skipping bloodline trust provisions, owning life insurance inside a taxable estate, maintaining outdated documents with the wrong people, or avoiding essential family conversations. Estate planning protects the people you care about most and provides clarity when you need it most. It's not just about minimizing taxes or creating documents, it's about ensuring your intentions are carried out and your family remains unified. The families who benefit most from sophisticated planning are those with complexity, multiple properties, business interests, substantial portfolios, because at that level, simple solutions, they create expensive problems. So if your situation involves that kind of complexity, there should be a link below for you to sign up for a time for us to chat. For everyone else, I hope that you subscribe to this channel. I put these videos out at least once a week. I really do enjoy making them, and I hope you'll join me for the next time.